Breaking news. In a jaw-dropping midnight decision, the Supreme Court has split 54 and sent shockwaves across the nation. This isn't the kind of ruling that gets announced during normal business hours with prepared press releases and scheduled briefings. This is a midnight emergency order issued while most Americans were sleeping, handed down with immediate effect and carrying consequences that are already rippling through every level of government. The surprise and speed of this ruling cannot be overstated. Legal experts went to bed thinking this case would be decided weeks or months from now, and they woke up to discover the Supreme Court had already acted. The decision had already been made, and the legal landscape had fundamentally changed overnight. This is a constitutional earthquake, the kind of seismic judicial event that happens maybe once or twice in a generation. The 54 split tells you everything you need to know about how contentious and high stakes this case is. The court's conservative majorities sided one way, the liberal justices dissented, and the divide between them reveals deep philosophical disagreements about constitutional interpretation, government power, and individual rights. What the court just did will impact states, agencies, and every law-abiding gun owner in ways that are only beginning to become clear. This midnight ruling didn't just settle one legal dispute, it established principles that will govern countless future cases, reshaped the balance of power between federal and state governments, and sent an unmistakable signal about how the Supreme Court views Second Amendment rights in the modern era. So, what was the case that shook the court and triggered this extraordinary midnight intervention? The contested law or policy at the heart of this case represented a fundamental challenge to Second Amendment rights. A state had enacted sweeping gun control measures that restricted where firearms could be carried, imposed extensive permit requirements, created broad categories of prohibited persons, and gave government officials substantial discretionary authority to deny gun rights based on subjective criteria. Gun rights advocates immediately challenged these measures as unconstitutional under the Supreme Court's Bruin standard, arguing that the regulations had no basis in historical tradition and violated the core right to keep and bear arms. Lower courts issued conflicting rulings, with some judges upholding the state law and others striking it down, creating legal chaos and leaving gun owners uncertain about what rights they actually possessed. The case was urgent enough for a midnight ruling because enforcement was already underway. People were being arrested, prosecuted, and having their firearms confiscated under laws that were potentially unconstitutional. Every day that passed without clarity from the Supreme Court meant more individuals were being subjected to government actions that might later be found to have violated their constitutional rights. The stakes were enormous, pitting state power against federal constitutional protections, collective safety arguments against individual liberty, and decades of judicial deference to gun regulations against the Supreme Court's recent Second Amendment precedents. The split decision shows deep ideological tension among the justices about how aggressively to enforce Second Amendment protections, how much deference to give state governments, and whether gun rights should be treated with the same rigorous constitutional scrutiny as other fundamental rights. This wasn't a technical legal dispute that reasonable minds could easily resolve. This was a clash of fundamentally different visions for American constitutional law. So what did the 54 decision actually do? And why is it sending shockwaves through the legal and political establishment? Breaking down the ruling in plain language, the Supreme Court's 5-justice majority struck down key provisions of the state's gun control law, finding that they violated the Second Amendment because they lacked historical support and imposed burdens on gun rights that went far beyond what the nation's tradition of firearm regulation would permit. The majority opinion made clear that the right to keep and bear arms is not a second-ass right subject to endless government restrictions, that states cannot simply declare vast areas to be sensitive places where guns are prohibited without historical justification, and that discretionary permit schemes that give officials subjective authority to deny constitutional rights are presumptively unconstitutional. Powers were expanded for individual gun owners and caled for state regulators. The decision empowers law-abiding citizens to exercise their Second Amendment rights with greater confidence and fewer bureaucratic obstacles, while simultaneously stripping states of regulatory tools they had been using for years to control gun possession and carrying. The language in the majority opinion signals authority and issues a warning to states that have been trying to work around the Supreme Court's Bruin decision through creative legislative drafting. The court made clear it will look past cosmetic compliance to examine whether state laws genuinely respect constitutional rights or whether they're just old wine in new bottles. The dissent from the four opposing justices reveals what they feared about this decision. The dissenting opinion warned that the majority is hamstringing states' ability to address gun violence, that the historical test the court is applying is unworkable and disconnected from modern realities, and that the decision will lead to more guns in more places with fewer restrictions, creating public safety risks that states will be powerless to address. The dissenters argued that the majority is imposing a rigid constitutional theory that ignores the practical consequences of gun deregulation and strips democratically elected governments of tools they need to protect their citizens. This is a turning point for constitutional law and gun rights because it represents the Supreme Court's most aggressive enforcement yet of Second Amendment protections in the post-Bruin era. The court is not just articulating abstract principles, it's actively striking down state laws, issuing emergency midnight orders to halt enforcement, and making clear that it will police state compliance with constitutional standards rather than deferring to legislative judgments about gun policy. What is the immediate impact nationwide right now in the hours and days following this midnight ruling? Rapid enforcement changes and freezes are happening across multiple states. The state whose law was struck down has immediately halted enforcement of the invalidated provisions, meaning people who were subject to prosecution or permit denials under those rules are suddenly in a different legal position. But the impact goes far beyond that one state, because other states with similar laws are now facing urgent questions about whether their regulations can survive constitutional scrutiny under the same analysis the Supreme Court just applied. Agencies and states reacted overnight with emergency meetings, legal reviews, and frantic attempts to understand what the ruling means for their enforcement authority. Attorneys general were pulled out of bed to read the decision and advise their governors. Law enforcement agencies that had been implementing strict gun control measures were told to pause enforcement pending further guidance, and permit offices that had been denying applications based on discretionary criteria were instructed to reconsider their standards. The uncertainty is profound because local laws may be halted or reviewed. Gun owners in multiple states are wondering whether restrictions they have been living under are still valid or whether this Supreme Court decision has effectively invalidated them. Local officials are unsure whether they should continue enforcing their gun regulations or whether doing so exposes them to legal liability for violating constitutional rights that the Supreme Court has now clearly recognized. Ordinary citizens are caught in a sudden legal shift where the rules governing their ability to possess and carry firearms changed overnight without warning. Someone who went to bed thinking they couldn't legally carry a firearm in certain places might wake up to discover that restriction has been struck down. Someone who was denied a gun permit last week might now have grounds to challenge that denial based on this new Supreme Court ruling. This is a nationwide ripple effect where the impact of this 5 or 4 midnight decision will be felt in courtrooms, police stations, government offices, and gun stores across the entire country for months and years to come. Now let's talk about why states are panicking in response to this midnight Supreme Court decision. There is enormous risk to state-level regulations that were designed to survive brewing by making cosmetic changes while preserving restrictive gun control. The Supreme Court's decision makes clear that those workarounds won't be tolerated and that states must genuinely comply with constitutional standards rather than paying lip service to them. Defiant states now face lawsuits, legal exposure, and emergency motions from gun rights organizations that will use this Supreme Court ruling as a blueprint for challenging similar laws in other jurisdictions. Every state with discretionary permit systems, broad, sensitive place restrictions, or subjective denial criteria is now a target for litigation that has an excellent chance of success, given what the Supreme Court just said. Internal reviews and fear of liability are driving emergency responses across state governments. Officials are terrified of personal liability for enforcing laws that have now been found unconstitutional. They're reviewing every aspect of their gun regulatory frameworks to identify provisions that might be vulnerable, and they're preparing for worst-case scenarios where large portions of their gun control apparatus get struck down in federal court. The message is unmistakable. Ignoring the Supreme Court comes with consequences. When the court issues a midnight emergency ruling striking down a state law, it's not making a gentle suggestion. It's exercising its constitutional authority to protect individual rights against government overreach. And states that continue to flout the authority will face judicial intervention, legal defeats, and erosion of their regulatory power. The panic is also political because elected officials in gun control-friendly states have built their careers on promising to keep guns out of public spaces and to maintain strict regulations on firearms. This Supreme Court decision undermines those promises and leaves officials scrambling to explain to their constituents why they can no longer deliver the gun control policies they campaigned on. So, what does all of this mean for gun owners across America? And how should they be thinking about this landmark midnight ruling? The protections strengthened for lawful gun owners are substantial and immediately actionable. This Supreme Court decision reinforces that the Second Amendment is a real constitutional right that places meaningful limits on government power, that states cannot subject gun rights to bureaucratic obstacles and discretionary denials that would never be tolerated for other constitutional rights, and that federal courts will actively protect gun owners against state overreach. The Second Amendment, which has been under sustained attack through increasingly creative and restrictive state regulations, is now being defended by the Supreme Court in the most direct and forceful terms. Yet the court is making clear that constitutional rights aren't suggestions or policy preferences that states can balance away in the name of public safety. They're limits on government power that must be respected even when the political branches disagree with them. Nationwide, legal uncertainty is being cleared in favor of rights. The post-Bruin landscape has been confusing, with different courts reaching different conclusions about what gun regulations are constitutional. This midnight ruling provides clarity, establishing that the Supreme Court will not tolerate state attempts to evade constitutional protections through clever drafting, and that gun owners have enforceable rights that courts must protect. Gun owners should stay informed about state-specific effects because, while the Supreme Court's ruling is binding nationwide, its application will vary depending on local laws and how quickly states adjust their regulations. You need to know whether the restrictions you've been living under are still valid or whether they've been invalidated by this decision. You need to understand what new legal arguments are now available if you're challenging a permit denial or defending against a gun charge. This is a win for liberty and law-abiding citizens who have been fighting for years to have their Second Amendment rights taken seriously. This midnight ruling represents the Supreme Court saying in the strongest possible terms that gun rights matter, that states cannot chip away at them through regulatory schemes that have no historical foundation, and that the federal judiciary will actively enforce constitutional protections even when that requires striking down popular state laws. So, what happens next? And where does this constitutional showdown go from here? Possible legal battles and appeals are already being prepared. The state whose law was struck down will likely petition for rehearing or for the full court to reconsider the decision, though such petitions rarely succeed. Other states with similar laws will have to decide whether to defend their regulations in court or to proactively repeal them to avoid expensive and embarrassing legal defeats. Gun rights organizations will file new lawsuits in multiple jurisdictions using this Supreme Court decision as their template and arguing that the same constitutional principles that invalidated one state's gun control law must also invalidate similar laws elsewhere. The potential political fallout is enormous because this decision will become a flashpoint in debates over judicial power, constitutional interpretation, and gun policy. Critics will accuse the Supreme Court of imposing its policy preferences and stripping states of tools they need to address gun violence. Defenders will celebrate the court for protecting constitutional rights against government overreach. And the decision will energize both gun rights advocates and gun control supporters heading into future election cycles. Supreme Court oversight is intensifying as the justices watch how lower courts and states respond to their Second Amendment precedents. If states continue to resist, or if lower courts issue rulings that the Supreme Court views as inconsistent with its guidance, we can expect more emergency interventions, more midnight rulings, and more aggressive policing of constitutional compliance. States and federal agencies are under intense pressure to comply because the cost of defiance has just been made crystal clear. When the Supreme Court issues a 54 midnight ruling striking down state gun control laws, it's demonstrating both the will and the authority to enforce Second Amendment protections aggressively. Officials who ignore that signal do so at their own legal and political peril. This 5-2-4 midnight ruling didn't just shake America. It set the stage for the next constitutional showdown over the scope of gun rights, the limits of state power, and the role of the federal judiciary in protecting individual liberty against popular majorities. What happens in the coming months will determine whether this decision represents an aberration or the beginning of a new era of robust Second Amendment enforcement that fundamentally transforms American gun